Good afternoon, all. Welcome to the Appellate Division, First Department. Our arguments for today, June 5. So you know the spiel. Please only ask for the time that you actually need to get out the salient points of your argument. We are fully familiar with your briefs, with your arguments, etc. The light is for you, not for us. Obviously, if we have additional questions, we will ask those questions. People v. Vincente Contreras. I'm sorry, how much time for rebuttal? 5, 1, and 5. Albuquerque versus Bedford Park Deli.
Respondents, Wilford and Tri-State, 5 minutes.
5, 2, 5, and 5. Matter of C, Alysa. 5, 2, and 5. Preister v. Fanar. Is there a respondent? There's no respondent. You still need 5 minutes? Certainly, 3 minutes. Lee v. Grimbalt. That matter is submitted. Paraza v. Rivier Capital.
Appellate respondent, 6 minutes and 5 on the vote, please, Your Honor.
Response? 6252. Board of Managers versus Frany.
Appellate, 5 and 2, please.
5, 2, and 5. Justice Kennedy is recused on that matter. People v. Cameron Hudson. That matter is submitted. Matter of Dashani. There is no appellant. Still one time? Certainly, 2 minutes. Diaz versus Nasser.
Appellate, 5 minutes, please, Your Honor. Respondent, 5 minutes, please.
You don't want any time on 5 and 5, thank you. People v. Yoel Belez. Belitz.
Appellate, 7 minutes and 3 for rebuttal, please.
626. Die v. RBNB 20 owner. That matter is submitted. First matter for argument is People v. Vincente Contreras.
Good afternoon, Your Honors. For Mr. Vincente Contreras, Mr. Contreras asks that his post-release supervision term be reduced from a period of 5 years to 3 years, as this portion of his sentence is excessive, given his relatively young age at the time of his offense. He was just 22 years old. At the time, he had no criminal record, and importantly, he accepted responsibility in this case. This was a plea of guilty to an SEI. The court may reach his claim because the waiver of appeal in this case is invalid and therefore unenforceable.
I always get these cases confused. Was this the one where he absconded for a period of time and then turned himself in afterwards? Was
No,
that, he
this-
didn't leave the location, leave the state?
This arrest did happen 4 months after.
Right, but he was missing for 4 months, wasn't there?
There wasn't a bench warrant period. It was just the incident occurred and the arrest happened 4 months.
Oh, okay, great, thank you. And he did not have any prior, he didn't have a prior misdemeanor or something in another jurisdiction?
There were no criminal convictions on his.
But did he have a YO, something like that?
No, there is no YO. And
Counsel, if I may, if this court finds that the waiver was valid, how would that affect the review of the excessive sentence claim?
so our position is that this waiver is in fact not valid, and I can explain that in a moment. However, if the court were to find that this waiver is knowingly, voluntarily, and intelligently entered into by Mr. Contreras, then it does foreclose this court's review of his excessiveness claim. However, this waiver is not valid, and a review of both the court's instructions to Mr. Contreras on the record, as well as a review of the waiver of appeal form that's part of this record, shows that there were important deficiencies.
And what were the deficiencies? Can you point to the deficiencies?
Yes. Judge, beginning with the court's instruction to Mr. Contreras, right off the bat, just seeing that this is a relatively young defendant with no criminal record and experience, the court does not make clear to Mr. Contreras that the right
He's represented by counsel, is that correct?
He is represented by counsel.
Okay, and counsel was present during the time of the plea, is that correct?
That is correct. However, a plea court cannot rely on defense counsel in ensuring that.
So why is counsel there? I mean, you have all these attorneys in the courtroom. What do they, what do we have them for? If we can't rely upon them to somehow instruct their clients. But again, what are the deficiencies in the plea allocution?
The deficiencies, Judge, first is that the court fails to make clear for Mr. Contreras that the right to appeal is a separate, distinct, and independent right that's ordinarily not forfeited when you plead guilty. Instead, the court unhelpfully states, and this is page 9 of the plea transcript, that the right to appeal is a separate, distinct, and independent right to have a higher court review any condition and sentence. However, that doesn't explain to the defendant separate, distinct, in what way? What is it that's different about these rights versus our trial or Boykin rights? And I would just compare the fact
I'm looking at the same page, actually, page 9. We can start with line 14. As a condition of your plea, you're also waiving your right to appeal. The right to appeal is a separate, distinct, and independent right to have a higher court review any condition and sentence, et cetera, et cetera, et cetera. So what's wrong with that?
So that doesn't explain to the defendant how this is separate, how this is distinct from your trial.
Does the
right.
case law require that? Can you give me a case that says that?
Well, Judge, generally speaking, I would point to the facts in People v. Cassadine, which is a Second Department case from 2018 that's referenced in the brief, where the waiver of appeal was struck as invalid, where the court failed to properly.
But it does not state anything, because I read that case. I read some of the other cases that you cited as well. But in that particular case, it doesn't state anywhere that the court is required to give examples or to give specifics in terms of how or what exactly, as I said, to give specifics, which is what you were referring to.
Well, right. So the court is not required to give any specific colloquy to the defendant. However, adding to the confusion, the court here states, by waiving your right to appeal once you're sentenced, the judgment of conviction will be final. And this is also page 9 of the transcript. The court then goes on to say, however, you retain the right to appeal certain limited issues. So a young defendant with the limited experience that Mr. Contreras has will not know how to reconcile these two seemingly.
And how do we know that? Was there any point in time where the defendant indicated that he did not understand exactly what the court was saying?
Mr. Contreras provided simply just one-word answers to the court's questions here. And if I may just finish my point, there is a waiver of appeal form which is signed at the very start of the proceeding. So the form says, listen, you have an opportunity to ask questions and clarify what this means with the court, but this is signed, and he's instructed to sign it by the court at the very start before the court has given any explanation of what a waiver of appeal is. And so the combination of the court's confusing instructions about a waiver and the form, which again, doesn't remedy the court's instruction.
The court asked about the form. She specifically said, did you discuss this waiver of right to appeal with your attorney prior to signing it?
Yes, she does.
Did anyone force you? Is this your signature?
Yes, she does ask that, but the court does not review the form.
What is she supposed? The judge is supposed to read the form to the defendant?
At the very least, the court had an
Again, do you have any cases to support that? Is there any case that says that the judge has to read the waiver of appeal, the written waiver of appeal, to a defendant?
The court's obligation is to make sure the record makes clear that the defendant, given the context, the defendant's age, the defendant's experience with the criminal justice system.
He was 22 years of age.
He's 22 with his first arrest, and he's a young adult.
Well, what was the bench warrant in Yonkers for? Wasn't there not a bench warrant that was issued in Yonkers for him?
It's referenced in the record. However, when you look at the CJA interview form and also the rap sheet, it shows 0 warrants. So yeah, something is on his rap sheet, but that's not a fingerprint result. The CJA, which conducts the search into whether there is an actual active warrant, says that there is no warrant. So that's the extent of his contact with the
Yes, you have
criminal
time on rebuttal. Thank you.
court. Thank you.
Good afternoon, Your Honors, and may it please the court. Kalani Brown on behalf of the Bronx County District Attorney's Office. Your Honors, we respectfully request that you affirm the defendant's sentence.
Was this a negotiated plea?
Yes, Your Honor, this was a negotiated plea.
And wasn't it a fact that many people were shot, a person, multiple people, and including a 5-year-old?
Yes, Your Honor, that is correct.
What would the defendant have faced had he gone to trial and been found guilty?
The defendant was facing up to 25 years of imprisonment on the top count of second-degree attempted murder, given that the people had a sufficient amount of evidence, witnesses, video surveillance. The defendant was given a windfall to his guilty plea to first-degree attempted assault instead. And so, Your Honors, I do want to note that the defendant was released to parole early, and he only served 4 years incarceration. And so he was released to parole December 12, 2022. According to the DOCCS website, he is set to be released from parole, or his parole is going to be finished on September 12, 2026, which means that he would have only been under supervision for 3 years and 9 months.
Counsel, if I may, now we know that the defendant spoke with his attorney, but anywhere did the defense counsel say, you know, Judge, I need a moment, my client doesn't understand, or, you know, I have issues with the colloquy?
No, Your Honor, the defendant did not indicate anything to that effect. And as counsel has stated, he did sign the waiver at the beginning of the proceeding. However, the judge did go into a sufficient detail in the plea colloquy indicating that the trial rights was separate and distinct from the rights that he would be giving up as a result of his guilty plea. And so the defendant did not ask for any additional clarification. At any point, he could have said, I would like to review the written waiver again. I'm not sure about, you know, signing it, but he reviewed it with counsel and he did not indicate anything to that effect.
And what about the allegation that the continued supervision is an extreme hardship for this defendant?
Your Honor, the purpose of supervision is the exact opposite, and it is to ensure that the defendant can properly integrate back into society. The probation department did indicate that defendant displayed a reckless and violent criminal behavior, and so supervision was absolutely necessary. If Your Honors have no further questions, I will rest on my brief.
Thank you.
Thank you.
Counsel, could you actually address that last point? I saw nothing in your papers as to how the post-release supervision would in any way interfere with his employment or family life, et cetera.
Well, Judge, Mr. Contreras is doing well on post-release supervision. I'm able to speak to that if the court would like. He has had no arrests since his release. He's gainfully employed. He's back living with his family. And if, again, I point to the CJI in this sheet, which shows that he lived at the same residence for 22 years. He's living with his family there now. He has acquired a certificate and works as a home health aide, which he has done since last year.
To continue if he's doing so well?
I think,
And how do we not know that the reason he's doing so well is because he has this level of supervision?
I would say rather than viewing it as a continued hardship, there is no further legitimate penological interest in having him continue on post-release supervision.
Well, how do we know that he's not doing so well because he's being supervised?
Well, I would say this. I think, and it's referenced in our brief, there's a growing understanding of the fact that post-release supervision is most effective 12 to 18 months
But
after
what
a
is that
defendant is
based on?
released.
I saw that in your papers. You said that 12 to 18 months, and it's no longer effective after 12 to 18 months. What is that based on?
It's based on the fact that most defendants who are released tend to reoffend within the 12 to 18 months 12 to 18 month period after their release. And beyond that time, increasingly the understanding is that there is no further purpose served, especially when a defendant like Mr. Contreras is doing well and has.
But again,
has
should we not look at
reintegrated.
each defendant individually? Some defendants may do better on post-release supervision and with supervision than other defendants. And as my colleague stated, why, if the defendant is doing so well right now on post-release supervision, why we would not assume that it's because of that supervision, which is the reason why he is leading a law-abiding life and no longer shooting two shots into a crowd of individuals, one being a 5-year-old and shooting that 5-year-old in the foot?
Well, first, let me say, understandably, the facts in this case are serious. However, the purpose of post-release supervision is to have a defendant successfully reintegrate back into society. Once he has shown that he's capable of doing that, as Mr. Contreras has shown here, there is no further purpose to continuing supervision. And I would argue with this particular defendant, it is appropriate to reduce the post-release term, both because it's excessive and because the interests of having him supervised have been met.
Is there any evidence that you have that suggests that it's impeding his reintegration?
Not that it's impeding, no.
Thank you.
Thank you. Thank you both. Albuquerque versus Bedford Park, Deli.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff appellant. If it's okay with you, I'd like to truncate my argument. I'll deal with the liability of the tenant first and then the owner second. I just think it's easier. This case actually caused me to rethink my general objection to specific interrogatories in personal injury cases. I generally can't stand them, but you know what? Clearly, I'm not right about that. You have specific interrogatories that the judge charged, the jury made findings. They found that the plaintiff fell where he said he was going to fall, that it was a defective condition, and most importantly, that the defendant tenant created the defective condition. There's no way that with those findings, under Busich and its progeny, there is an inextricable link between the negligence and proximate cause. Certainly, you don't have to, a finding of negligence doesn't mandate a finding of proximate cause, but when those issues are inextricably intertwined like they are here, they are. Now,
Wouldn't the proper course be to have raised that and then have the jury have an opportunity to take another look and come back?
listen, I'm not going to tell you, Your Honor, that Barry against Manglass doesn't say exactly that, and the Grisiak against the City of New York doesn't say that. But this isn't even inconsistent. I think what the lawyer was probably thinking was just there's an inextricable linkage, and it's against the credible weight of the evidence. I agree. That's always the best way to do it, and I'm going to get into that when I deal with the dismissal of the case with the plaintiff. As you.
So let's just stick with that. So let's say that the argument can be made that it was inconsistent, and since we all agree that that wasn't raised, how would that affect your argument?
It wouldn't, because both you and the second department have both held that you waive a claim of inconsistency by not raising it, but you can always raise a claim that a verdict is against the credible weight of the evidence. I think your case is called Ramos against New York City Housing Authority. I think it's a 280 AD second, but there's no question that that's the rule. It would have been better to do that here, assuming the judge accepted it. But I just don't think there's any basis to finding that there's no inextricable link. And to give my adversary credit, he doesn't actually talk about the logical coherence of the argument. What he does is he says the plaintiff was convicted of a crime, he didn't take photographs, he drank a little bit, his testimony wasn't what it was supposed to be with respect to damages. That has nothing to do with that issue. So to me, on this record, given the court's findings, there's very little question that the negligence finding with respect to lack of proximate cause won't hold. With respect to the owner, and I'm going to get to your decision is this case Rosario, which specifically says, even though people don't follow it, it's always better to reserve, right? Reserve on a motion to dismiss, let the jury give its verdict, and then if the jury does something wrong, you set it aside. If it doesn't, there's something to go back to. We don't have that here. I'm assuming Mr. Simone is going to say to you, because he's a terrific lawyer, he's going to say, look, even though the case was dismissed, there was no expert testimony, there was no specific testimony that the plaintiff saw this defect beforehand. And why are you objecting, Mr. Isaac? Because you have specific interrogatories which say that the tenant was affirmatively responsible. Let me just deal with those right now. First, nobody who falls on a defect sees it beforehand. If they say, I saw it beforehand and I stepped on it anyway, you got a huge proximate cause problem. You've held in a case called Porco against Marshalls. It's not in the brief. I just want you to know that I did send a letter to my adversaries telling them every case I was going to cite so they could be prepared. Porco against Marshalls says you don't have to see it. Moreover, even if the defendant created the condition, another defendant created the condition, you can have 2 or more actors who were negligent. And the testimony, as far as I read it, and obviously I didn't read the brief, I'm reading it like you are cold. The accident happened in the archway. You can look at page 904 of the record. Everybody says that that area was an area that was the responsibility of the owner of the premises. And even if the tenant did, in fact, create this condition through that ridiculous decision to put hot water on ice in freezing temperature, it doesn't mean it didn't exist for a sufficient period of time where you have a February 2 snowfall of 6.1 to 7 inches, and then an accident happening 3 days later at 7 o'clock in the morning. I would also point out, again, this isn't in the brief, but I did tell my adversaries about it. I read your decision in Massey. It's Massey against Newburgh W Realty, 84 AD 3D 564, First Department, 2011. And a second case that refers to it's called Lakins, Lakins against 171 East 205th Street Corp. That's 118 AD 3D 451, as saying that you don't necessarily need expert testimony in a case like this. My procedural arguments, I think, are secondary. Unless you have any questions, I'll rest and rely on my brief. Thanks for listening to me.
Good afternoon, may it please the court. My name is Michael Andre on behalf of the Bedford Deli respondents. Counsel is arguing that the jury's verdict is inconsistent against the weight of the evidence. That is simply not the case here. There is sufficient evidence here, and as this court knows, it's a very high standard to set aside a jury's verdict. The Court of Appeals has held this has to be simply a finding that there was simply no valid line of reasoning or permissible inference to allow the jury to come to that conclusion. Yes, here this jury did find that the Bedford defendants were negligent in causing this ice condition. They believe that this deli manager, his custom and practice was to pour hot water on the sidewalk, and that somehow that water rolled uphill in front of the archway that counsel just referenced. That was the area that was the landlord's obligation to clean from snow and ice, and that caused him to slip and fall. The jury can believe that, yet under these facts and under this, given the circumstances of this particular plaintiff and his character, which they sat 5 feet away from him and sized him up, that there was sufficient evidence to conclude that he did not cause this injury, or they didn't believe that it was a substantial factor in causing his injury. He got up, walked home, made no complaints to the multiple stores, including the Bedford Deli that was open. They took no photos. This is an experienced litigant who's had prior slip and fall litigation where he'd taken photos. He sought no medical treatment for 27 hours. He went home, carried about his business, reports to the ER with claims that he has pain in his ankle, and there's mention that he popped it into place. There was also testimony that he lied on to his doctors, that he would testify that he was convicted, like counsel referenced, he had prior conviction for a DWI.
He said he was a social drinker.
That he was a social drinker and blatantly contradicted by his doctor who testified and at the ER. So there's a litany of credibility issues here. Then like I mentioned before, the no treatment in the 27 hours after the accident. These are, again, I'm not saying how I would have concluded and how we have all seen these facts, but there's enough here to permit a jury to conclude that Mr. Albuquerque may have fallen here, but it's not a substantial factor in causing his injuries given what we've seen and heard.
And we don't know because the jury was dismissed.
Yes.
We don't know exactly.
We don't know exactly. The jury was dismissed. And it's permissible inferences here. Like I just talked about, the inference that this jury made based on the deposition testimony of the deli manager, that it was his custom and practice. They inferred that he poured hot water and that it rolled uphill and caused this patch of ice to form. These are, again, inferences that were made based on the record in this case. An appellant touches on several procedural issues. Rests on his papers. I'll just briefly touch on them. They're significant. That's a significant remedy to strike the Bedford Deli's answer. The judge at the trial level, gave a missing witness charge as to the witnesses. The video, is wholly speculative. There was no testimony during any deposition that it was even pointed at the area where it would have captured images of this sidewalk at the time, and it clearly wasn't destroyed. The testimony was that it would record over itself every 6 months, as is a pretty commonplace for establishments like this. And then I'll briefly touch on the expert issue. Dr. Mrozek was disclosed 2.5 months before the trial. We designated him as an alternative IME because the initial doctor who examined the plaintiff became medically unavailable to testify. Appellant refused to consent to go to the exam, moved for order to show cause to compel it. Court denied it. And the trial judge limited Dr. Mrozek's testimony to his review of the films, the records, and he was bound by the four corners of the initial IME exam. So there's clearly no prejudice, does not warrant the striking of the Bedford Deli's answer on any of these grounds. So I'll rest on my papers unless the court has anything further.
Thank you.
Good afternoon, Your Honors. Christopher Simone for the respondents, Vilford Realty and Tri-State Management. If I'm a great lawyer, Mr. Isaac is a phenomenal lawyer. And I can see why the plaintiffs. And I can see why the.
I mean, because it's the end of the term, that's why. So if this was
way to end?
September, forget
I'd
it.
be snappy. And I can see why the plaintiffs hired him, because this case is the epitome of speculation in a slip and fall case, okay? The case law is legion that you need evidence of actual constructive notice. Actual notice is not an issue here. Constructive notice is the only thing here. But there's zero evidence of notice here. The only thing the plaintiff put in there was put his own testimony that he slipped on ice. This court's jurisprudence, the mere presence of ice is not enough. There are no photos of this ice. There is no evidence of any origin. There's no
But,
evidence
Ms. Isaac's point is well taken. If he saw the ice, then he wouldn't have stepped on the ice, right? If you see ice, at least me, I'm not stepping on the ice. I'm going to walk around the ice, assuming
I'm
I can do
not
so.
suggesting that he had to see it in order to have liability. That's just another factor here. It's not even testimony that he saw it. I mean, there's nothing here. The crux of the plaintiff's argument, the entire argument rests on these weather reports. First, it's not even clear if these things ever made it into evidence. At 490 of the record, the court didn't let them in because they weren't certified. And then the next day, on the 27th of January, there's a directed verdict motion where, and it was these weather reports were never even discussed at trial except at sidebars by plaintiff's attorney.
So it sounds like
they weren't discussed at all.
So
Pardon?
they weren't admitted into evidence.
It doesn't look like they were, because even though the exhibit sheet says it was admitted on 127, there's nothing on 127 admitting them. We know the court wouldn't let them in, but he talked about them during the argument, and then there's no exhibit tab on just those. But putting that aside, they don't get the plaintiff where he needs to be. The weather records show that the temperatures were above freezing for almost a full day before this accident, from 1 p.m. on 2/4 to 7 a.m. on 2/5. The plaintiff's entire argument, both in his brief at page 16 and at trial, was the reasonable inference from this data is that the ice formed when temperature was below freezing. How is that a reasonable inference?
Well, it
3 days before.
fluctuated, right? I mean, the data showed that the temperatures fluctuated.
They fluctuated, but
Below freezing, above freezing.
But for 21 hours before this accident, they were above freezing. They didn't start to get below freezing until after the accident. So how is it a reasonable inference to say that 3 days before this accident, ice formed that no one ever saw, 66 units in this building, 1, 2, and 3 bedroom apartments, hundreds of people, nobody ever saw this, formed and remained there during above freezing temperatures? That is, this case law is legion. That is the epitome of speculation. You want to sell that to somebody? You got to have an expert for that. I'm sorry. I mean, I'm not a thermal expert, but that doesn't make any sense to me. That's exactly what the case law says. You can't just speculate that, well, since ice was there, it must have formed. Well, his clothes were wet.
How else did it get there?
Well, his clothes were wet. Well, I don't know. But that's a plaintiff's responsibility to prove that. The mere presence of ice is not enough. His clothes were wet. And the jury later found that the Deli affirmatively created this condition. And I want to point out one thing. Mr. Isaac said that the accident happened in the archway. It didn't really happen in the archway. It happened away from the archway, closer to the curb. That's page 904.
Well, it's kind of unclear, I think. from the
Yeah, and he
plaintiff's
testified it's somewhere in that area.
Yeah, he said it was around
And
there.
he also testified, the owner testified that the ground is sloped. So I'm not going to do it, but if I throw a glass of water from over here,
Please
it's
don't.
going to hit Mr. Isaac.
Yeah, don't.
It's
Don't throw it at
even
Miss
though
Isaac
this is his
either,
property,
either,
right?
please,
But I wouldn't do that because he's a phenomenal attorney. If there are no further questions.
Oh, love that.
You gonna hug it out? Okay, go ahead.
So, Your Honors, if I can, there's no dispute that the plaintiff fractured his ankle, 675 of the record. I mean, that's the defense expert said he fractured his ankle. And the fourth interrogatory was formed in respects of injuries. So there's just no logical way that you can find in this case, based upon the jury's finding, that there is an inextricable linkage with respect to the tenant's negligence and causation. I would just also point out to the court that there's a case called Marrero, I should give you the site, and I did give it to my adversary. It's actually my case, one of the few I won. Marrero against 2075 Holding. It's 106 AD 3D 408, First Department, 2013. Specifically says that you can get summary judgment even if you're a convicted felon, and that the argument that you're a convicted felon doesn't mean that your testimony is entitled to no weight where it's undisputed. With respect to what Mr. Simone said, if I could just 30 seconds and I'll sit down. I think his view of the weather records is wrong. If in fact it was hot, not hot, it's the wrong word, if it was over freezing, right, 32 degrees or above for the 20 to 24 hour periods preceding the accident, which is what the weather records show, that would show that that ice would have been there longer, because if it wasn't, it would have melted. That, I think, was the point. And I don't think you need an expert in every situation where you have ice and snow that occurs on February 2 with an accident.
Don't you need an expert to testify as to the ground temperature versus the air temperature in terms of, I mean, I've seen cases where that's what the expert would talk about. So I don't know what the ground temperature was at the time, and as opposed to the air temperature, and therefore whether it would in fact melt or.
Justice Weber, it certainly would have been easier for me if I had an expert that didn't have undisputed testimony. But the fact is that I do have facts. Juries can always use their common sense. I have a adverse weather event, February 2. I have no intervening acts except perhaps, we're not really sure, this unique method of removing ice and snow, but it's still there in hot temperature. And I have He against Troon, which says there's a non-delegable duty on the part of the owner to detect that. So I think there's enough not to have summary dismissal. Thanks again.
Thank you. Thank you all. Matter of Alysa C.
Good afternoon, Your Honors. May it please the Court, Eva Jerome for ACS.
Counsel, I don't usually like to ask for updates unless I think it might result in mooting the issue before us. So I'm curious that since the permanency order in front of us said that there was going to be a next permanency hearing early in April, almost 2 months ago, did that occur? And has there been an order from that hearing?
There's not been an order from that hearing, it's my understanding. But
There's no subsequent
reports.
There's no subsequent permanency hearing order?
Correct.
Okay. My second question to you is, it's a fundamental part of our jurisprudence that we defer to the credibility findings and the findings of fact of the trial judge, especially in a non-jury case. Why isn't that applicable here? You're asking us, it seems to me in your brief that you're asking us to look at the evidence as you describe it and form different conclusions from it than the trial judge did. Why is that appropriate under our jurisprudence?
This court, of course, has the power to do just that. And
I understand that, but it's still a basic principle that we don't do it unless there's a really good reason to.
It's appropriate because the family court in this situation, there was evidence of its abdication of some of its duties. In fact, it never made credibility determinations.
It didn't say, I find this person credible and that person not credible. On the other hand, if one reads all of its conclusions, it's obvious who the trial judge credited and who they didn't. So I think you're putting form over substance.
Well, to the extent that there's inherent credibility determinations, let's think about whom. And Ms. F is a legal stranger to the children.
But that doesn't determine that she's not credible.
I'm sorry, not a what?
That doesn't result in a finding that she's not credible.
Right.
I mean, yes, she is a legal stranger to the children, but it seemed to me that everybody in that courtroom agreed that the children had a closer relationship to her, all of the 4 children, than to any other adult that anybody knew about, and that she was the only adult who had been a continuing and loving presence in their lives for the previous 6, almost 8 years. So I'm not sure why the fact that she's a legal stranger is really the critical fact here.
A couple of points, Your Honor. There's no doubt that she was absolutely incredible for the children for 6 years. But the catalyst for the removal, for the sleepovers to stop, were Ms. F herself.
Yes, I agree with that. But what's interesting is that Judge Heddleman, who presided over the abuse hearing, also was the first judge to put into place an order continuing visitation with Miss F with the children. So it's clear to me that Judge Heddleman, having heard all of the very distressing facts about this situation, nonetheless concluded that it was important for the children to continue spending time with her. So how do you square that?
And ACS agreed at the time, the traumatic upheaval from removing the children, ACS wanted to keep the siblings together. And ACS worked with Ms. F because she had 3 possible permanency placement arrangements. One with her aunt, which didn't work out, one with a family friend, it didn't work out, and then ultimately her brother, it didn't work out. So there was...
Well, there's no evidence in the record that the situation with the brother did not work out.
I think it's in the brief.
At the time of the...
Right, at the time that
At that time, there was no evidence that that hadn't worked out. So let's stick to the record that was before the court at that time.
Of course, thank you. The evidence is that after, it's time, it's been 2.5 years, it's time for the children to not have the whiplash that they were experiencing from...
And what evidence is there that they didn't have that whiplash and that they didn't still need Miss F in their life? I didn't see any evidence of that in the record. I read test statements by ACS counsel to that effect, but I didn't read any testimony that showed that they didn't need Miss F in their lives at this time. Could you point me to any testimony that actually showed that the children did not need Miss F in their life at this point?
Yes, I can.
Page?
No, I don't have the page. It's testimony of Ms. C, with the C family, testified about how the children were changed after they came back.
And she also testified that she had no objection to the children continuing to see Miss F, correct?
I don't believe I don't recall exactly, but I want to point out an important point here is that you're talking about having Ms. F in their lives, and we're talking about weekly mandated visits.
But isn't it often the case that children, after visits with anybody, come back to where they've been and they're affected by it, right?
It's affecting their ability to have viable permanency options.
And where is there evidence in the record that it affects their ability to have a viable permanency relationship with another adult? I didn't see any evidence that supported that. If you can point me to anyone, I would find it very helpful.
The fact that they haven't had a permanent option yet is...
Well, that doesn't mean that they couldn't. It doesn't mean that the relationship to Miss F was preventing that. It just means they haven't. Maybe they were placed with the wrong people. I don't know. But it's your burden to show that. How did you show that?
If I may, there's evidence about the cell phone messages that somebody sent purporting to be the children.
And it could have been from the children. There's no evidence that it wasn't from the children, right?
The caseworker testified that they never had her phone number. And
okay, but the caseworker also testified that she didn't know whether...
She didn't know, but
so that's not unequivocal, correct?
That's not unequivocal?
It's not unequivocal that the text messages did not come from the children.
Right. That's true. But...
Counsel, did Ms. F ever file a petition for visitation?
Yes. Excuse me, 1 second.
I don't think she ever requested.
Not visitation, for custody and for guardianship.
Oh, she filed for custody and guardianship?
She did, yes.
So you mentioned the text messages. So the issue as to the text messages was that the caseworker did not believe that these text messages actually came from the children?
Right.
And that was based on what?
The caseworker said that the language was more mature than the children at that age would have known about, and the fact that she never gave them the phone.
Were the children ever questioned as to whether or not they actually sent those text messages?
That's not in the record, Your Honor.
Okay.
And counsel, the text messages weren't in the record either, were they?
They were not in the record, no.
Oh, so again, in the record, what is there in the record to support a finding that the children should not have supervised visits with Mrs. F?
We can't lose sight of Ms. F's adjudicated terrible neglect finding against her.
But I think the point by my colleague was the same judge who sat on that case also ultimately granted visitation to Mrs. F. So if, in fact, the facts that came out during that hearing were so egregious and so heinous, I guess, then the judge would not have allowed the visitation. Can't we make that assumption?
I imagine, I know that ACS wanted to allow the visits to be supervised with Ms. F. even after they were moved from the home.
Okay, so
Because of
what
the
changed?
transition, a massive upheaval, and there's no.
So I understand that. I understand that the children have had a relationship with Mrs. F for a long period of time, 6 years, and there's this concern that since there's no path to adoption by her or by her brother or aunt, then therefore there should be a clean break, I guess, so that the children can be free for adoption and not have any thoughts as to Mrs. F. However, does there not have to be some support for that other than, speculation or feelings as to the children? And don't we have to look to the best interests of the children and the fact that they have formed this relationship with her?
We do. There's the evidence of the therapist's report to the court, which the family court did not consider, that the therapist said for the oldest boy that the visits with Ms. F were not, quote, not good, unquote, and prevented him from bonding with his current foster family. We have.
I'm glad you brought that up. I want to talk about the social therapist, and I'm just going to paraphrase because I was under the impression that when the court asked her what, if any, safety concerns she had regarding Miss F, I believe her answer was that there were none, and that she was basing her concerns on maybe what someone told her.
That may be, I don't recollect that particular point about the record, but what is in the record and is undisputed is that while the children had overnight visits, were allowed to have overnight visits at the aunt's house, Ms. F made the terrible judgment of having the PLR, who was by then adjudicated to have sexually abused her own daughter, sleep over in the house. She continually has put her own interests above the interests of the children since they have been taken from her. 2 years is long enough for visits. I'm not saying that they can't have contact, but they can't have weekly visits where they're going to face whiplash every time, and with preventing
Counsel,
them.
you're arguing she's a legal stranger and there's no basis under the law for her to have visitation with these children. Is that your argument?
That's correct.
Thank you.
Good afternoon, Your Honors. Judith Stern, appearing on behalf of the children. As Your Honors,
Counsel, picking up where I left off with her. Yes. Under the law, Ms. F is a legal stranger. Under what statute, case law, are we allowed to give visitation to these children?
Your Honors, this case arose in the context of a permanency hearing, and the request was by the attorney for the children. And in a permanency hearing, this is not a custody case. Permanency hearing, it is the job of the court to make a determination what's in the best interest of foster children. This is not a custody case or a visitation case where it's going to be the adult, the legal stranger asking for custody or visitation. That's as against a parent, and it makes sense in the.
But what if? Sorry to interrupt you, Counsel, but it's in my nature as a judge. But what if the current foster mother, who has these children in her care, doesn't want visits between the children and Ms. F? She's now bound by this order?
The foster parent is not a parent. Foster parent can't make those determinations.
I hear you, but we're working towards permanency with this foster parents, the carries and the older child, correct?
No, I'd like to clarify that record because that's the record that they've presented.
Let me hear it.
All is not, as rosy a picture as my opponent.
It hardly ever is, Counsel.
So where are the children now? Are they with Mrs. F?
I'm sorry?
Where are the children now? In
So
whose
they're
custody?
in separate foster homes, and, you know, the older children they haven't, I don't want to, you know, reveal confidentialities, but it's still a very disruptive situation. They're still asking for Miss F all the time, and in fact,
So doesn't this support her argument that
does
there's no ending to this because they're still hopeful about Miss F?
no, they're not asking, they understand, everybody understands. It was made clear, it was made crystal clear to Ms. F, it was made crystal clear to the children. Our attorney told the children, there is no path. That is not what's going to happen in this case.
And didn't one of the children say that why waste my time with these visits?
No, they want contact. This is the single most important adult in their lives. She nursed them back to health. They came to her in such a traumatized situation, and for 6 years she nursed them, she cared for them, she supported them, and this is their lifeline. This was their lifeline. They need to have her in their life. The oldest child just contacted the attorney for the child, and she's asking, can Miss F come to my 8th grade graduation? She's a significant person in their lives, and the law has now recognizes, as so does the court, that they've expanded the definition of kin to extend to significant adults. They understand the importance it is to these children.
So, counsel, as to the permanency hearing that was held in April, there has not been any determination as of yet?
The termination?
Was there any ruling or decision?
No, I mean, there's a stay at this point. This court has issued, so the court couldn't have changed the outcome of that.
Counsel.
It was only of that part of the order that was at issue. It was a stay of the entire.
It was my understanding it was a stay of the orders allowing contact between the children and the.
That wouldn't have prevented a permanency hearing, would it?
I think everybody's under that understanding it would be.
No, but the permanency hearing, so what was the purpose of the hearing then if the
Well, there's always permanency hearings for reasonable efforts, for determination about, you know, what the goal is, what's going on with the children. I don't like that. I mean,
was that discussed at the hearing, the visitation by the foster mother?
I wasn't.
I'm sorry?
I doubt it. I mean, really, honestly, you know, everybody's was working under the impression that the court granted the stay pending the appeal, and then expedited the appeal. So,
But there was no actual stay of the family court from holding a permanency hearing.
no, but the permanency hearing, that wouldn't have been part of the permanency hearing. The permanency hearing would be the foster care placements, how the children are doing in school, that's what this was not part of the permanency hearing.
Counsel,
Wish it
I like
were.
to go back to the testimony of the social therapist. Now, the court did pose a question to her as to whether or not it would be in the children's best interest to, you know, totally end contact with Miss F. And I believe the answer was she wasn't even sure.
She acknowledged, specifically, it's in my brief, she acknowledged that Ms. Miss F treated the children well, they loved her, and they were attached to her, and that she could not say that separating the children from her was in their best interest. So she specifically said that.
And what about the allegation that Ms. F allowed her boyfriend back in after him sexually abusing their biological child?
The family court said, okay, why don't we then have an order that these visits cannot happen when he's in the home. They're younger children.
But he wasn't supposed to be in the home, and he was. So how do we know that she will follow that order, Ms. F?
Ms. F will follow that order. I mean, she has shown herself to be willing to do everything she can to maintain a relationship with this child.
Aren't these supervised?
Was that the proviso in the order that the court?
I honestly, Your Honor, I don't recall that being part of the proviso. I do not recall that.
The boyfriend be barred from
From
the...
my understanding, there was no, that was not something that I recall being some kind of a bar to.
But having these supervised visits would allay any fears.
For sure, having supervised visits, and the court, you know, she will abide by any rule that this court or that the court provides, so long as they can have a relationship and a continued relationship. And I want to really stress that this court, as your honors noted, this is exactly the kind of case that requires this court's deference. This was a judge, these were two judges that presided over this case for a long time, and they repeatedly, not once, not twice, but time and time again, made a determination that it was in the children's best interest to have contact with Ms. F, and the judge who heard the case against her, the neglect case, was the same judge who issued rulings over and over again, as well as the judge who followed.
The order in front of us calls for visitation and does not explicitly say anything about the boyfriend being excluded.
No, Your Honor.
Nor does the February 2023 order say anything
No,
about
none of the
boyfriend
orders
being
say that.
excluded.
There's been no
So
reference.
how is she, I mean, how could she have violated it if it didn't
I mean,
say that?
you know,
I agree, it wasn't a good idea, but I don't see how why it's a violation of the order.
yeah, I agree.
Thank you.
Thank you.
If I may point to a few more instances in the evidence in the record. Ms. F was the one who was overheard saying to the children, pray that you don't have to be with Ms. C anymore, the C
But that was after one of the children had told her that Ms. C had cursed at them and had done other things that seemed untoward. So one could interpret that as a loving, supportive statement to say, if this person has not been nice to you, you should pray that something changes. Why isn't, it seems to me that there are at least two interpretations of that. One, that it's a loving, supportive statement, and the other, that it's manipulative. It's clear that Judge Broderick saw it as a loving, supportive statement, or she wouldn't have ordered continued visitation. So who are we to step in and say, not having seen the witnesses, that Judge Broderick was wrong in reaching that conclusion?
It's the fact that maybe the role for Ms. F is to attend one or two big events a year. We're not saying
I'm not.
no
You
contact.
didn't answer my question.
Sorry.
Why should, given that there are at least two possible interpretations of the prayer statement, and it's clear that the trial judge adopted one, what possible basis is there for us to reinterpret that?
It's not supported by preponderance of the evidence, Your Honor.
So you're saying that the interpretation that the trial judge made is not a possible interpretation of the statement, that was a statement by a supportive adult who wanted to acknowledge that she'd heard what the children had been saying?
Given the totality of the circumstances, the fact that Ms. F said, pray that you don't have to be with them anymore.
What is the totality of the circumstances that require us to interpret it in that way, as opposed to the way the trial judge who heard the testimony clearly interpreted it?
What more about the totality of the circumstances? I'm sorry.
I don't understand what it is that should cause us to reject Judge Broderick's interpretation of that statement and adopt yours instead.
At the very least, this court should direct the family court to allow ACS discretion to taper visits therapeutically. They're still in limbo.
Well, that would be one thing if you'd brought in any therapeutic testimony at all, but none of the experts you brought in provided any therapeutic or medically thoughtful or psychologically thoughtful evidence about what was happening, did they?
Well, there is my opponent likes to discredit the sociotherapist, but I want to say that the therapist at the New York Center for Psychotherapy is the one who said the visits with the older boy, with Ms. F, are not good for him and are preventing him from bonding with his foster family.
That was not an opinion held with a reasonable degree of psychological certainty, was it?
I'm sorry?
That was not an opinion held with a reasonable degree of psychological certainty, was it?
No, but the court didn't address it at all.
So ACS's position is that you don't you're not opposed to contact between Mrs. F and the children, you're just opposed to,
An ongoing weekly visitation with no end in sight.
okay. And so was there a proposal that there be an end in sight, an end date, or a reduction in the visits?
I believe the the ACS attorney requested the discretion to taper off the visits or to have them or make them therapeutic visits.
And where are we now in terms of the adoption process?
Well, there's no adoption allowed for Ms. F.
Yeah, I understand that. So in general, where are we? Because you mentioned the bonding, and therefore that would foreclose adoption. So where are we?
My understanding is that the two eldest children, who are full siblings, are building a relationship with their biological father. My understanding is that the two younger children are with Ms. C. They're back and requested to go back to Ms. C. Those are viable permanency options. The
So
biological.
the two older ones have a relationship with the biological father,
Yes,
and the younger one wants to go with Miss C.
did want to go back to Ms. C from the foster family right after the permanency.
Was there anything in the record concerning the feelings of the biological father as to whether there should be continued visits with Mrs. F?
I don't know about visits. Obviously, he definitely surrendered his rights with the proviso that Ms. F be the one to adopt the children, which was then had to be returned. But I don't know about visitation.
Thank you.
Counsel, you were in support of, ACS was in support of visits,
Yes, absolutely.
and is changed its position because, briefly?
Over time, the evidence has made clear that Ms. F is impeding the children's ability to move on, and it should be up to the permanency resources to do the child raising without weekly in-person visits with Ms. F.
Last thing, why did the IPCP did not work out with the brother in Georgia?
I have the ICP, I have copies of the ICPC letter if the court.
No, I just want to know, why didn't that option work out for the kids? That's Miss F's brother.
Georgia closed the house, did not approve of him. There were red flags for Georgia.
Thank you.
Thank you. Thank you both.
Thank you.
Preister v. Fanar.
Good afternoon, Your Honors. Michael Gertzer, Law Office of Jennifer Adams, for appellants Ramona Harrison and Davia Anderson. So I just want to make three very quick points before I rest on my papers. The first is this particular case falls under an exception to the typical rule against successive summary judgment motions that was set forth in the Ellie line of cases that I cited in my brief. Second point I wanted to make was that the first motion, the motion concerning.
How does it fall under the exception?
It falls under the exception because there's a line of cases starting with Reed versus Brown and continue through Ellie versus City of New York, that the questions of liability and serious injury can and should be determined separately. And specifically in Ellie, it was found that.
But this is clearly liability. Both motions for summary judgment were based on liability or the lack thereof.
In Ellie, the first motion, I believe, was a liability motion. The second motion was a serious injury motion. In this case, the Preister case, the first motion was a serious injury motion. Second motion was a liability motion. So the arguments are unrelated. And under the case law, it squares with the Ellie case. It's just flipped. So the next point I wanted to make was that the first motion was pending at the time that the second motion was filed. Had we simply withdrawn the first motion and filed a second motion containing both arguments, there would have been no reduction.
Or waited. You could have waited, right?
We could have done that, but there would have been no reduction in the burden to the court. The court literally could have had both motions before it. It did have in front of it and could have determined both at the same time. The basis for the court's decision denying the second motion was that the existence of the second motion created an added burden to the court.
Now, plaintiff is not here, but plaintiff did not object to the second motion for summary judgment.
Correct.
Has not put in any papers in opposition to this appeal.
Correct. The only opposition brief was put in by the co-defendants.
You had a third point, or is that it?
The third point I wanted to make was that had the second motion been determined on its merits, it should have been granted, and which would have also thereby reduced the burden on the court, since we would have removed Ms. Harrison and Mr. Anderson from the case and would have streamlined any future trial.
Thank you. Paraza v. Rivier Capital.
Good afternoon, Your Honors. May it please the court, Scott Matthews of Windells, Marks, Lane and Mittendorf, on behalf of the defendants, appellants, respondents, Rivier Capital Advisors, and 4 individuals. Your Honors, the motion court correctly dismissed 9 out of the 10 causes of action that the plaintiffs brought. It should have dismissed the lone cause of action that it sustained. This dispute stems from plaintiffs' contention that they should be provided with a transaction bonus for a transaction that hasn't occurred. Unfortunately for all parties, HAI Technologies, the plaintiff's former employer, has not sold the product that is known as the oil recovery tool. This is undisputed. It's in the record.
But a security interest in ORT Technologies has been granted, correct?
Yes, Your Honor. Rivier Capital pledged its interests in HAI Technologies and HAI and all of its other holdings as well in exchange for a $6.25 million loan. That loan transaction was used to benefit HAI Technologies and the commercialization of the ORT.
And Rivier as well, right?
And Rivier as well, Your Honor. Yes. And the plaintiffs argue that that loan transaction qualifies as a transaction under the definition in their employment agreements that they're also suing and claiming they were fraudulently induced into entering into. And they're simply incorrect on the definition. Your Honor, the contract states that a transaction is defined as any transaction or series or combinations of transactions and related financings, whereby, directly or indirectly, control of or a material interest in the oil recovery tool, intellectual property, and or product line is directly or indirectly.
Why would that not, the fact that they now have there's a loan, and so there's a security interest in the business, why would that not be a material transaction? Why would that not be included in the language in terms of material, how does the language say? Material interest.
It's because the contract specifies that the plaintiffs would be paid a transaction bonus upon the sale of the ORT. And when they defined what a transaction is, and the contract is replete with instances related
Why
to the
didn't
sale.
they put that language in? Why didn't they put that in?
They did, Your
When they
Honor.
define, and they say material interest in, and now you say it requires a sale.
I don't see material interest in the definition, Your Honor. I apologize.
Where does the language about a sale appear in the contract?
It appears in the contract at paragraph Schedule A. It appears in the recitals. It appears in
the recitals.
It also appears in
But not in the definition section, correct?
I beg to differ, Your Honor, and the definition is any transaction or series or combinations of transactions and related financing. So therefore, you have.
Yes, but where does the language about a sale appear in the definition? The language about the sale only appears in the recitals, not in the definition, correct?
No, Your Honor. There's a number of examples in the contract itself.
But none of those examples have, there's nothing.
Where the word is.
I don't see where the word sale appears, except as an example or in the recitals.
It also appears, Your Honor, at Schedule 8, subsection of Schedule A, Section 8BA, where it defines what the transaction value would be, which is based on the, quote, sales value of the ORT, intellectual property or product line.
That's a that's an issue about remedies, not about what the definition is of what a transaction is.
Well, actually, I'm not sure I agree with that, Your Honor. Respectfully, you cannot calculate the amount of the bonus unless there is a sale. In fact, that's what Schedule A provides 7 illustrations of in order to determine the sales value.
But I'm not sure that you can then go backwards from that to say that you therefore have to, that a transaction can only be a sale because the damages arising from it as defined by a much later provision in the contract.
Well, if I look at the
use word
definition,
sale, but in the definitional provision, it doesn't use the word sale, right?
it does. It actually says, including without limitation, a sale or
Those are
exchange.
examples, but it doesn't preclude that other things, or say, including only those, right?
Doesn't say only those. It illustrates that that's
Those
what
are
it
examples.
means.
But
Well,
that doesn't mean it's exclusive, right?
it's not exclusive, correct, Your Honor. But it's strange logic to suggest that a loan transaction whereby Rivier has to repay monies to a financier, to a lender, would qualify as a success fee, basically, for these individuals to be entitled to a bonus upon
That may be a strange provision, but that doesn't make it part of the definition.
No, but we have to look at what the result of the definition would be in order to come to its understanding. You have to look at all
Counsel,
the
what's
terms of the
remedy?
contract. Yes, Your Honor.
What's the remedy if they default? What's plaintiff's remedy if they default? They've pledged this for the loan, and then there's a default.
What would be plaintiff's remedy?
Yeah.
Plaintiffs would then, presumably plaintiffs would assert that it qualifies as, I'm not sure that has any impact on their transaction bonus, Your Honor, because I don't believe that it constitutes a transaction. If they transfer the interest and they default and the lender takes it, I submit that that does not qualify as a transaction upon which they're entitled to a bonus. We have to remember that the company received a loan and has to pay it back. There is no default as it stands now, as far as I'm aware, Your Honor, that there has been no transfer of a controlling interest in the ORT. There's been a pledge of all of Rivier's interest in HAI, which owns Hydroacoustics, which owns the ORT. And I would also point out, Your Honor, that HAI is the contraparty to this contract. It's not a party to this action. We have a pending arbitration in which they're claiming a breach of contract. The court below sustained the breach of contract claim, one that plaintiffs did not even oppose in the motion hearing in writing, on the basis of alter ego liability theory. The claims of domination do not go to the harm that the plaintiffs allege. The claims of domination relate to supposedly not putting monies into a HAI bank account that was entitled to go there, and for taking control of the board, which is done every day when you have a controlling shareholder appointing persons to a board, and those members exercising their fiduciary duty to the organization that they work for, and just because they're notwithstanding the fact that they were put there based upon an affiliation with a shareholder, but they don't allege any harm as a result of that. The Sweetwater loan does not come about because of that. Thank you.
Good afternoon. Ariana Tadler for the plaintiffs, respondents, appellants in this matter. We're here today because the lower court erred by acting both as the trier of fact, making conclusions of fact as well as credibility, and also misapplying the law as to 10 distinct claims. Each one of those claims really has the ability to stand on its own. We've alleged that accordingly. And quite frankly, with respect to what Mr. Matthews has just shared with you, insofar as the definition of transaction, it's quite clear. It's very broad. And to the extent that the court decided in any way, it rightly decided in our favor because it is so broad. And if the other side is actually questioning the breadth or scope or application of that, at best, it's an issue of fact.
So reading the contract as a whole, how do you interpret what counsel described as the remedies provision, which specifically references a sale in order to determine the remedy?
I don't think that that's in any way dispositive at all. The fact of the matter is that there are ways to determine what the appropriate remedy would be, assuming that in this instance we have a loan, $6 million loan. our clients were entitled to 9 or 10% each of the value of whatever that transaction was. We say that it was 9 or 10% of the value. Once we get through a trial of this matter, we will determine the extent to which the remedy is going to be valued. That provision about limiting it to somehow a discussion of sale to determine what the value is in no way changes what the definition of transaction in this contract says.
And what about counsel's argument that there's no proof of domination?
That's absolutely not true. In fact, we have listed a whole number of factors with respect to domination and control throughout the complaint and also through our papers. I find that really difficult to even contemplate. If you look at our brief document 11, pages 23 through 24, we have all of the TAP factors listed there, and there you have all the references to the record. It goes on for 2 pages. Inadequate capitalization, commingling of assets, degree of discretion demonstrated by the dominated corporation, payment or guarantee of corporation's debts by the dominating entity, overlap in ownership, officers, directors, and personnel, defendant's failure to adhere to corporate formalities. If I were to list all of these things for you right now, my time would run out pretty quickly because it's 2 full pages with quite a number of references to the record. Recognizing that I only do have 5 and 2 here today, I do have a couple of things that I just want to make sure I do cover, and that is that with respect to personal jurisdiction as to Mr. McGrath, the other side would like you not to look for the man behind the curtain. The man behind the curtain is here. He has been here. He's availed himself of our state for the rights and protections that are offered by New York State. And in fact, to the extent that they tried to push him out of New York State, they put in what they consider documentary evidence to somehow negate that he was here, and quite frankly, it helped us very much. Mr. McGrath was here at least 4 times during the relevant period of time, including if you look at the context with respect to when these agreements were being negotiated, when the transactions were occurring. Negotiations about these employment agreements started in November 2016. Mr. McGrath was in New York in December 2016. Then the negotiations continued all the way through March 7, 2017, March 8, 2017, the agreements are signed. Lo and behold, Mr. McGrath, who doesn't come to New York often apparently, or at least according to him, actually shows back up 1 week later, March 15th, 2017.
Don't you need more than his presence in the jurisdiction? Don't you still have to show that he engaged in some type of activity? The activities in New York were purposeful and established a relationship between the transactions and the claim asserted? I mean, the fact that he's here in 2017 and 2 weeks later something is negotiated, he's domiciled in the United Kingdom, and we know that. So again, where in the record is there any correlation between his being present here in this jurisdiction and the transactions occurring?
So I'm not sure if you're asking for purposes of articulable nexus or if you're asking for purposes of due process or both.
Nexus is what I was looking for.
So throughout our complaint, we talk about Mr. McGrath being behind the scenes. If you look at A73 through 76 with paragraphs 54 through 59, you'll see that there were, we were talking about what was happening behind the scenes and during that period of time. We also know very specifically that Mr. McGrath actually participated in advising on and negotiating the relevant agreements for the ORT, O-R-T, which is the technology that is at issue here. These defendants—
And that participation took place here in this jurisdiction?
It didn't have to take place here to the extent that he was even participating in Zoom calls, conference calls, emails, where he was actively and purposely availing himself. That counts. We have Deutsche Bank, and we also have Fishbarg. Also, we do know that Mr. McGrath did come to New York, and although we attempted to correct the record below by putting an additional affidavit in, the affidavit itself didn't get in, but my friend did put the substance of what Mr. Paraza put in for the record, and it is in the transcript, specifically that there was a meeting with Mr. McGrath and other defendants at the Rivier offices about HAI, ORT, and plaintiff's duties, and there was a subsequent lunch at Cellini Restaurant on 54th Street. He came here, he sat down, He sat with our clients and talked about all of this. Moreover, Mr. McGrath is also the co-founder of Rivier Capital Advisors, and that is an entity. His face is front and center on the website. Its principal office is in New York. That company is registered in New York. He has purposely availed himself of being here, both in terms of in general and also with an articulable nexus as to everything that we've alleged in this case. And by the way, this is a case where our clients were ultimately exited from their responsibilities, and therefore most of the information does not reside in our clients' documents, their repositories of information. The information actually resides with the other side. And we're very confident. In fact, I can look at you all and say I'm 100% confident standing here today that the information that is available through discovery absolutely will speak to the fact that Mr. McGrath purposely availed himself. So to the extent that you determine we need to have jurisdictional discovery because you don't think we have enough, rest assured, we're going to do a bang-up job.
Counsel, I wanted to follow up on my colleague's question here. Can you refer us to the specific paragraphs in the complaint where you allege that defendants exercise their domination of HAI and, committed a wrongful act towards that?
You're talking about the TAP factors and then the wrongful conduct,
Yes.
Your Honor.
Where in the complaint?
Yes.
Paragraphs.
Sure. So I would have to point you, again, all of these are very detailed in connection with our brief on pages 23 and 24, and then carrying over to 25. And you will see that with respect to inadequate capitalization, it's at A77, A79, A83, A86, and A89. Commingling of assets. Defendants transferred funds from HAI bank accounts.
No, you don't have to read it. Just point us to it so I have it.
Oh, sure. A67 through 68, A88, A89. Also, A60 through 62, A80 through 81, A88. A1295, that's actually not part of the complaint, so in fairness, you've asked me about the complaint, I want to be responsive to, Your Honor. A86, A89. Also, A61, A60 to A62, A61, A152, A88, and then we have a few other references that are not specifically in the complaint, meaning a paragraph of the complaint, but we most certainly give you a lot of details about all of this.
Thank you.
Thank you.
Your Honor, just to pick up where counsel just left off, counsel just read off a number of record pages, but didn't read off any paragraphs in the complaint. Actually, just gave you record pages that relate to the complaint. With respect to Mr. McGrath, I would point out that there is no record evidence of Mr. McGrath negotiating the ORT. In addition, the pages and paragraphs in the complaint that counsel just referenced with respect to the alleged nexus between Mr. McGrath and the negotiation of the amended contracts does not relate to Mr. McGrath. It relates to Mr. Walter, paragraphs 54 through 59. Mr. Walter, not Mr. McGrath, is the person who negotiated the amended employment agreements with the plaintiffs. I don't know if counsel was miscommunicating what happened, but it's not referring to Mr. McGrath in paragraphs 54 to 59.
What about his alleged relationship with Rivier?
Mr. McGrath is an investor in and a lender to Rivier. He is a minority shareholder in the company, but he is a large minority shareholder in the company, and so he has a voice. The Rivier contacts him and seeks advice and information from him, but at no time does it seek approval from him. And if discovery does go into it, this court, I am 100% confident that there will be no basis for personal jurisdiction over Mr. McGrath. And if
Nice to see two confident attorneys.
we're both very confident. But I would say, though, that if
Wasn't he one of the co-founders of Rivier?
he's listed on the website as being a co-founder, but
Wasn't he? So you're saying he wasn't a co-founder?
I don't know what the word means, to tell you the truth, Your Honor. I know that he is an investor in Rivier. He's not on the board. He's not an officer. He's someone who holds an interest in Rivier, and through Rivier holds an interest in HAI and some other companies. But but he has not purposely availed himself of the laws of the state of New York and was not at the meeting that Mr. Paraza claimed occurred or the lunch that Mr. Paraza said occurred at a different time because
What about the emails? Wasn't he,
he received emails, Your
he
Honor.
was copied on, why would he be CC'd on the emails?
Because he was a valued advisor to the company. And so when something of importance came up, like the renegotiation of the executives who run one of the companies, one of Rivier's portfolio companies, they would from time to time consult with him and bring him up to speed on these issues. It doesn't mean that he was negotiating the contracts that were allegedly fraudulently entered into. He was not at the meeting that Mr. Paraza and Mr. Smith verified that he was at. And Mr. Paraza admits that he was wrong about that, and he takes it back. But he cannot claim that he was there for personal jurisdiction and then not be able to state it to support his claim for fraud in the inducement.
Thank you.
You're welcome, Your Honor.
Board of Managers, I'm sorry, did you have rebuttal? I apologize. Yes.
Thank you, Your Honor. I do hope, Judge, that I did answer your questions. I believe your questions were posed to me with respect to paragraphs and in the complaint regarding the TAP factors of domination and control. My colleague here suggested that you were asking for something else. If I misunderstood you, please do let me know, just to tap on a couple of...
Counsel, I actually wanted to go back to transaction because, again,
Sure.
Schedule A defines transaction as a sale or exchange of assets, a lease of assets with or without a purchase option, formation of a joint venture, minority investment in or partnership in the assets, or any similar transaction. Is it any similar transaction that gets us to the loan, which is a liability, as being included?
Actually, it's quite a number of those elements. That definition is quite broad, and we have the security interest, we have the investment component. All of those things go to the extent to which a transaction occurred. And right now, all we needed to do was allege sufficient facts for purposes of getting over a motion to dismiss. You will note that in the record, the entire Sweetwater transaction series of materials are not before you. My colleague did not put all of those materials before you. So at best, we have a question of fact. At best, we have a question of fact.
Again, you talk about sale or exchange of assets. To me, that would mean the receipt of some type of cash, assets, or equity, or something like that in exchange for the ORT, right? As opposed to the Sweetwater loan, which is a liability.
So we shouldn't really call it just a Sweetwater loan. The Sweetwater event, it is a series of transactions which include $6 million of debt that are collateralized and through which an interest was pledged at a value of over $6 million. So it's far more than that, and quite frankly, there was a time when in the negotiations, the concept of sale and sale alone was on the table. That is not what the contract says. The contract is broad. They have to live with it. If they can prove that what happened with respect to Sweetwater doesn't amount to a transaction, they can prove that. Not on this motion to dismiss.
Thank you. Thank you both.
Thank you for your time.
Board of Managers versus Francisi is the next matter. As stated, Justice Kennedy is recused on this matter. The rules of the court are that if there is a tie, another judge will be vouchered in. Whenever you're ready.
Good afternoon, Your Honors. May it please the Court, Robert Bernstein of Holland and Knight for the Plaintiff Appellant Board of Managers of the residential section of the Plaza condominium. The issue that we're putting before this Court today is a relatively simple one. This case has been around since 2015. At no point ever has any judge, and there were 3 that handled this case, including Justice Kennedy, ever dismissed a cause of action for breach of contract against the Defendant Board of Managers.
But there isn't a breach of contract claim at this time, correct?
That's correct. That's correct. So what we have asked this Court in this case where some facts are undisputed, it's undisputed that our client paid almost $4 million more than it should have, that money was collected by the respondent, that was used to settle the debts of the respondent's constituent members so that they benefited from it, whether there's a viable cause of action that should continue. So the only thing that we're asking this court to do is to look at Justice Adams' decision and see whether this case should have been disposed, which is how the decision indicates the case is, so we could not make a motion to amend the complaint.
You could have made a cross motion to amend, which of course properly would have included a proposed pleading. You didn't do that. So how is that issue before us? I mean, you cite the relevant section of the CPLR as 3025B.
Correct.
Which requires that if you want to move to amend, if you want to amend, you need to make a motion and attach a proposed pleading. You didn't do that. So why 9 years after this case is filed should we say, oh, it's okay?
Well, because, Your Honor, and I'd like to answer that question. It's because this case was only dismissed recently, and the cause of action for breach of contract was part of this case for years. It was not included in the third amended complaint, but they're certainly on notice. And what's critical here is that the time to make this motion, as the statute says, is any time. And motions to amend and amendments of pleadings have been made after cases are finished with trial at the Court of Appeals level. So the question here is, what's the right result in the interest of justice?
Isn't the right result that we should generally follow the CPLR, which says make a motion and attach a proposed pleading?
Oh, absolutely, and we're prepared to do that right now.
You didn't do it, so why should we do anything now except for rule on what's before us?
Well, the question is whether that should be barred. And what's before the court right now is whether Justice Adams correctly disposed of the entire case. So
she disposed of the only issue that was in front of her.
Correct, but it's undisputed that during the motion practice, we had suggested to Justice Adams that she should allow us to amend if she dismissed the case. So there was no reason to move to amend at the time when there were other causes of action that were still pending. There were 3 causes of action before the court. And it was only when those causes of action, which would have been deemed duplicative of a breach of contract cause of action, were dismissed, that we then should have been permitted to make the motion to amend.
Counsel, I'm not understanding.
Yes.
Judge Adams dismissed the cause of action for conversion.
Correct.
That is what you are appealing.
We're appealing her decision as a whole.
Her decision is that she granted defendant's motion to dismiss plaintiff's cause of action for conversion.
Conversion, unjust enrichment, and monies hadn't received. She dismissed 3 causes of action.
Oh, but I thought you weren't appealing from those parts.
Right, you're only appealing the dismissal of the cause of action for conversion.
If you'll look at our brief, Your Honor, what we're saying is that the court erred by not permitting us to amend and marking the case fully disposed, which prevented a motion. So on a motion 3211.
That issue of permitting you to amend wasn't in front of her because you hadn't made a motion. Why should she reach beyond what's in front of her and grant you relief that you hadn't properly asked for?
The issue is timing. On a 3211 motion, she could have said, and we submit should have said, I'm dismissing these causes of action, but I'm giving the plaintiff leave to replead.
And on within the first year or so of a case, that would be a likely result. But 9 years in, why would a court do that?
Well, Your Honor, only because you're saying 9 years in, but it was not 9 years in at the time.
8.5.
But
I mean, come on, really. But again, I'm really not understanding your argument, and I apologize. But the only issue that I see on appeal, based upon the brief submitted, is the granting of defendant's motion to dismiss your cause of action for conversion. That's all I have.
Your Honor,
I see no other issue on appeal.
The first of our statement of questions presented is, in dismissing appellant's third amended complaint for failure to state a cause of action, should the motion court have permitted appellant to replead its causes of action rather than dismissing the complaint outright? That's our first question.
How is that in front of her, except by your saying, hey, would you also consider this?
Well, I'm not.
That's not how you request relief from a court, is it?
I understand, but we didn't have the relief to request until she issued her decision, right? Until the case was disposed and until those other causes of action were no longer pending, there was no need for that relief. There was a decision to pursue the quasi-contractual claims. When she dismissed those, we needed the breach of contract, and no one has decided that that's not a meritorious cause of action.
You chose a couple of complaints ago to drop that one.
Well-
So why should she reinstate it now?
The only issue is that we have in the third amended complaint all of the facts necessary to support a cause of action. So what we're asking for is in the interest of justice, not to allow a $4 million claim to evaporate, to allow us to litigate on the
Interest
merits.
of what, Justice? I'm not, I still don't understand. But perhaps you can explain it again on rebuttal.
Sure.
Thank you.
Very, very succinct.
Rebuttal.
I'm sorry. I
Rebuttal,
didn't-
that means that you sit down and then she argues and then you can state
I
that.
understand, Your Honor, I didn't hear you. I apologize.
It's okay. No problem.
Good afternoon, Your Honors. May it please the Court, Kara O'Sullivan of Kaufman, Waterston, Ryan, for the respondent, the Board of Managers of Plaza Condominium. My colleague here says that his issue is a simple one with respect to the opportunity to amend. And Your Honors did succinctly point out that the third amended complaint in this action had 3 causes of action and not what appellant is now asking for in their, which they did not bring up until their reply, which is an opportunity to amend on and bring forth a breach of contract cause of action. This was not requested in the initial papers until the reply. We believe this is a new claim for relief and should be disregarded. This is a third amended complaint, and yes, there were breaches of contract in prior complaints. However, the complaint that matters, the third amended complaint, which is the one that was before the lower court, did not have a breach of contract cause of action. It's misleading to say that it was never dismissed, because if that is the case, then whenever an amended complaint comes forward, then the parties would have to take into consideration all prior complaints.
Right, so I'm looking at the third amended complaint, page 42 of the record, as in for a first cause of action, conversion. Page 43 of the record, as in for a second cause of action, money had and received. I do not see a cause of action for a breach of contract.
There's not in the third amended complaint. Prior contracts, it was affirmatively abandoned by the appellant when they drafted their third amended complaint. Therefore, the motion to dismiss from the respondent in the lower court was for the 3 causes of action that were before it: conversion, unjust enrichment, and monies had and received, which, our position is that the lower court properly dismissed of those claims.
So you're saying it was asserted in some prior complaint?
Correct. They were.
It was asserted in a prior complaint, and when they moved to amend, they removed it.
Correct. It was not brought.
And you moved to dismiss?
It was not brought within this. I apologize.
That's
for
okay.
interrupting. It was not brought within this third amended complaint, a breach of contract.
And now you move to dismiss this third amended complaint. They oppose, and they add a sentence: if you're inclined to dismiss it, allow us to amend.
Correct. They're asking after the fact. There was no affirmative relief was asked for, nor was there any.
They didn't cross-move to amend with
No
proposed
cross-move to amend, nor putting forth an amended complaint, which one would have do if they moved under a third, moved under the CPLR to amend the complaint. No other questions. I'll.
Thank you.
Mr. Honors. Thank you.
If I may,
So counsel, your claim is that you alleged a breach of contract in some prior complaint, right?
2 prior complaints.
But neither of those is in front of us as part of the record. Am I correct?
You are correct, absolutely, Your Honor. You're correct. So the only issue, and
So you're asking us to decide on something based on something that isn't in front of us?
that's I would put the issue differently. What we're saying is that Justice Adams indicated in her order that the case is disposed and did not reach the issue of whether we should be permitted to amend or leave us an opportunity to make a motion to amend.
Counsel, you should have cross-moved to amend. When they filed their motion, you could have cross-moved to amend and attached the proposed amendment.
The question is, what should the consequences of that be? So under the CPLR, under 3225, we can make the motion at any time. And
Maybe you didn't make the motion at any time at all.
we'd like the opportunity to now, and we've been prevented to because the case is marked disposed. So the question is it within the jurisdiction of this court to grant that relief? And as far as the justice question that I was asked to answer earlier, there is no question that our client has been deprived of $3.7 million plus. And so the question is...
We don't know that yet. That hasn't been established.
It hasn't been established, but
It's alleged.
It's not disputed either. It's not disputed either. But that's been alleged. So on a 3211 motion, we read the most favorable view of the complaint. The allegations are considered true. And the question is whether, because there wasn't a cross motion made at the time of this, time of the motion to dismiss, whether that should preclude us from making one later. And there is no case law
See,
site.
counsel,
Counsel,
what
9
the-
years, 4 amendments.
Right, eight and a half. But counsel, my problem is that in the prior two complaints, the Second Amendment complaint and the First Amendment complaint, I don't know which one it was, the first complaint, you did allege a cause of action for breach of contract, did you not?
It was, the plaintiff did, Your Honor. It was, different law firms had the case.
You're the plaintiff, it's still you, right? It's you.
I'm saying
Your client. Who
I'm
the-
saying yes, Your Honor.
Okay, so that's what I do not understand, because now in the Third Amendment complaint, you apparently abandoned that cause of action for breach of contract. I could understand perhaps if it had never been alleged, and so now with the dismissal in the Third Amendment of the Third Amendment complaint, you're saying, oh, well, you know what, we never alleged breach of contract, so now because the complaint has been dismissed, we should now be able to amend a Fourth Amendment complaint and allege breach of contract. But you abandoned the breach of contract claim.
We elected to put forward the quasi-contractual theories.
You say elected to put forth the quasi-contract, and I say abandoned.
Well, correct.
And I think under the statute, it would appear that it was abandoned.
But it's not affirmatively abandoned, and the only issue I'd like to leave the court with is that the law is very clear, that leave to amend should be considered at any time.
And do you have a lot of case law supporting that after you've had 3 amended complaints and 8.5 years have passed?
Well, again, Your Honor,
And you had already put forth that claim for one of the cause of actions, and then you abandoned it.
the issue is whether this should be litigated on the merits or on these technical reasons. And 8.5 years, yes, but the case had gone through different parties, 3 different judges, and so really this issue was not being litigated for 8.5 years. And we would only like the opportunity to address it on the merits in the end. We don't think it's a major.
And I'm sure you promise that you will get it right for the Fourth Amendment complaint, right? Thank you both.
Thank you.
With a full confidence.
Full confidence, that you're fully confident.
The theme of the day.
100%.
100% confident. Madam Jashani? We're 4 seconds in. I'll
Good
start it
afternoon,
all
Your Honors.
over
Thank
again.
you. May it please the Court, Floria Nagy from Paul Weiss, Rifkin, Wharton, and Garrison, pro bono counsel to Ms. W. and co-counsel with Sanctuary for Families. There's a very high bar to overturning a trial court's credibility findings. An appellant must show that the trial court's determination lacked a sound and substantial basis. Mr. T has not even come close to meeting this standard. I'll just note the trial court said that the petitioner testified credibly, consistently, and emotionally during her case in chief about several instances of abuse, several of which occurred in front of the children, who as a result remained fearful of Mr. T. The order stated that it was the court's deep concern that the violent behaviors observed both in open court as well as by the children would hinder their development as well as their physical and psychological well-being, both in the short and long-term basis. Now, on the other hand, the family court found that Mr. T's contradictory testimony was incredible and implausible and consisted just of blanket denials, stating that he was not responsible for the attacks on Miss W. and the children. The court further noted
the propriety of the full 5-year stay away final order?
Sorry, Your Honor?
Would you address whether it was appropriate for the court to impose a 5-year full stay away order?
Absolutely. There's 2 independent reasons why that is appropriate here. Number 1, repeated violation of a prior order of protection by the Kings County Criminal Court. Number 2, also under Section 827, occurrences which the court constitute an immediate and ongoing danger to the petitioner. Family courts routinely find, on this basis, aggravating circumstances and 5-year orders of protection where the respondent, like here, committed family offenses in front of the children and, as the record says, is therefore an ongoing danger to them both physically and psychologically. Each of these 2 on its own is an appropriate and independent basis for granting of aggravating circumstances. Together, they make an unshakable record which should not be overturned on appeal based on the papers here. Mr. T could not even be calm and collected before the court itself, and therefore the finding of aggravating circumstances should not be disturbed. Thank you very much, Your Honors.
Thank you. Thank your firm for allowing you to proceed to take this case on a pro bono basis. Thank you very much.
Your Honor.
Diaz v. Nasser.
Good afternoon. If it please the court, Joseph D. Donato, Bennett, Brooklyn, and Salisbury for defendant appellate Michael Shannon, MD. This is a very simple procedural issue. The argument here is that the motion judge incorrectly extended the plaintiff's time to serve the summons and complaint under CPR 36B.
It's undisputed that he wasn't served, correct?
It's undisputed, Your Honor. The motion judge held that. The complaint was filed in a multi-defendant case. 700 days later, with the defendant not having been served, a motion for default was filed. That was opposed, and there was a cross motion to dismiss the complaint. At no point in time during those proceedings did the plaintiff move for, raise, or in any way mention an application under 306B to extend the time to serve the complaint. In fact, the first time I found out about it was when the motion judge issued her opinion, and there it was before I had any chance to oppose it or present the reasons why there was no factual basis for good cause or the interest of justice. And then that's the appeal. The question is that motion should not, that sua sponte relief should not have been granted. Unless the court has any questions, I have nothing further.
Good afternoon, Your Honors. Joseph Chacho for the respondent plaintiff from Napoli-Shkolnik. What appellant is essentially asking this court to do is limit the discretion for the first time afforded to judges by the Court of Appeals in the Leader case to extend a plaintiff's time to serve in the interests of justice.
What was the interest of justice?
The interest of justice here, as analyzed by Judge Gerrigs of Bronx County, was that the interest of justice was that the plaintiff should be afforded more time to serve. That diligent attempts were made to serve the defendant, that there is
What were the diligent attempts?
The diligent attempts, Your Honor, was that he was served at places that we confirmed he had been previously successfully served at the office that he practiced medicine.
But I thought that he did not practice medicine at that office.
He did practice medicine at that office. He claims to be an independent contractor, not an employee. So the issue is whether the office had the authority to accept service. But at no time did the office tell us that they were not accepting service, not on the first complaint, not on the second complaint, not on the default letter.
I just want to go back. So what you're saying is that you raised this below, because I was under the impression you did not, and this is new.
We did not officially ask for an extension of time.
Well, no. That really wasn't the question, so let me repeat it.
Sure.
The question is that what you're raising now, that he was served in all of these other places, did you raise that below? Because I didn't think you did.
Well, Your Honor, that was the purpose of our default.
No. That's a yes or no. It's so simple.
Yes, I believe we did.
Can you tell me where in the record that you raised that?
I don't have the specific pages, Your Honor. I apologize. But we had moved for default because we believed he was sufficiently served.
Let me ask you another question. But now he resides in Ohio, and the principal place of business is in Ohio.
At some point, he was living in New York, practicing medicine in New York.
No, that's also like a yes or no. He lives in Ohio, yes?
They claim he lives in Ohio.
Okay.
Yes.
So let me do another one. And the principal place of business, Ohio.
That's their claim, yes.
Okay. Independent contractor of the facility.
That's their claim,
Okay.
yes.
Thank you.
So I just want to make clear that I heard you. You didn't ask for the extension of time to serve?
We didn't, Your Honor. Okay, but it is well within Justice Gerrigs, and hopefully I'm saying Her Honor's name correct. Perez's, I'm sorry. Authority, and it's clear from the Court of Appeals that it's within her authority and her discretion to grant that. I've had judges tell me before in the past that there are 3 possible ways for me to do this: what plaintiff is asking for, what defendant is asking for, and what is right. And what the judge in this case did was come to a compromise. We moved for default because the defendant was served at a place that he had been successfully served many times before, a place that accepted service for the defendant and at no time refused to accept service for the defendant, a place where the defendant was listed on their website as a doctor practicing at their office.
I just want to get a clarification. So you did move for an extension of time.
No, we did not move for an extension.
Ah, okay.
So when you say that the office accepted service, do you mean that they didn't throw it back at the process server, or do you mean that they signed received on behalf of Dr. Nasser?
Right, the former, the latter, Your Honor.
They actually signed received on behalf of Dr. Nasser?
No, I'm sorry. They did not
so
refuse service. They didn't
They
affirmatively.
didn't throw it at the person, but they didn't say, oh, yeah, we know Dr.
Right.
Nasser.
What typically happens, at least in medical malpractice, Your Honor, if we go to a hospital to serve a doctor and that doctor is not an employee of that hospital or does not work there, the hospital will say, we are refusing service. We are not accepting this summons and complaint for Dr. So-and-so. We are not responsible for him. He does not work here.
This is not a hospital. This is the Brain and Spine Surgeons of New York, which appears to be some type of an office, right? It's a medical office.
Right.
And the summons was given to the receptionist, who, as my colleague stated, did not say received on behalf of Dr. Shannon.
Right.
It just simply took it, received it. And also, the record seems to indicate that Shannon, again, was not, he was a consultant to brain and spine surgeons.
Right. So
And his picture was on their website, you said?
yes, they listed him as one of their doctors. There's no dispute that he practiced medicine there. He saw patients
No, I
there.
thought there was, but the dispute was his relationship to
Correct, the legal relationship.
his legal relationship, therefore their ability to accept service on his behalf.
Yeah, and to be clear, I'm not here, nor am I appealing the issue of the lower court judge in denying our default motion. That was decided. We did not win on the default motion because service was not effective. But the Court of Appeals and all the cases that that cite the leader case from the Court of Appeals, it's not an issue of was service good or not. It was a diligent attempt made, and under the interest of justice standard, there doesn't even have to be any diligent attempt.
So the diligent attempt was what?
Serving him at a place we knew that he was served before.
But can I ask about the 2-year delay? Because that's what counsel said. Only at that point were they aware of this, and it was 2 years later.
That's what they claim, Your Honor. Again, he was served there. He was attempted to be served there with both complaints and the letter, a default letter, and then the default motion. It was not until that facility received the default motion did Dr. Shannon appear. So clearly the facility told him about the default motion. I can't prove, nobody can prove whether the facility told him about all the other complaints they were getting for him. And
So you didn't move for a default until 2 years later.
approximately, yes, Your Honor. And that's why our default motion was denied. But again, under the interest of justice.
So the default motion is denied, and then Shannon moves to dismiss, and then that is when you move to, that's when you make your request for an extension of time.
No, that's when Justice Jerez gave the extension, as is her discretion under the Court of Appeals.
So you didn't actually make that motion, you just said, hey, can we have an extension?
Right, it was her compromise. It was the judge's compromise under the discretion given her by the Court of Appeals. And again, all the cases cited by defendants are completely inapplicable here. It's a very broad, very flexible standard under the leader case, and there are no cases that apply such a stringent standard as defense counsel is asking, or I'm sorry, appellant is asking this court to apply. If this court were to rule in appellant's favor, it would be creating an entire new standard on the interest of justice standard by the leader court. There are cases where interest of justice was applied where plaintiff never even attempted service, let alone attempted service, and it didn't work.
And where
So-
they didn't make a motion?
And I don't know if they made a motion or not, but
You don't think that's
whether we
irrelevant?
made a
You
motion.
don't think that's a relevant?
I don't think it's relevant, Your Honor, respectfully, because again, it's in the judge's discretion to give any relief that her honor or his honor deems in the interest of justice. That's what we put at the end of all of our motions, and we request any other relief that this court may deem just.
Thank you.
Thank you, Your Honors.
Thank you. People v. Yo Bellas, Belize.
Good afternoon. May it please the court. I'm Zachary Margulis Onema on behalf of appellant Yoel Belitz.
Bellas, thank you.
Your Honors, this case is a classic example of what I call the Johnson anomaly. So the board scored 30 points, way below the number required for level 2. And in disregard of the Johnson case that directs 80 points to be scored in this situation. But the board also provided a thoughtful analysis of the real risk that Mr. Belitz may pose and found that that risk was a low risk. So they declined to impose points, which the Johnson case has said must be applied even in child pornography cases for the category 7, which applies points if the victims are strangers. Because in child pornography cases, a person is much more dangerous if they know the victim of the crimes. So
I have trouble understanding that. He had in his possession many videos of children doing things that children shouldn't be asked to do by any adult.
correct.
The children who were filmed doing that suffered harm from being filmed doing that.
Correct.
They wouldn't have been filmed doing that if there wasn't an audience for it. He's part of the audience for that. So how can you say that he's not dangerous? I don't understand the argument. It seems to me that were he not an audience, along with the other people who do that, they wouldn't be filmed doing these things, and then that would be a very different situation.
The question is he more dangerous if the children are known to him or are not known to him?
I think that's a close question. In either event, he's dangerous, and I don't really see that we have to decide which one's worse in order to decide that it's a bad thing.
But there's no question it's a bad thing, and he was punished very severely for it. The point, though, is to assess.
Well, he was sentenced to a conditional discharge.
Yeah.
And he had to serve 5 years of supervised release with special conditions. So I'm not really clear as to the conditional discharge, as opposed to a term of incarceration. But again, that was the feds who did that, so that's on the feds.
The basis for that conclusion was largely that he wasn't dangerous based on the three.
I don't know what the basis for that conclusion was. The fact remains, as I agree with my colleague, I don't know if you can really measure what is worse in terms of the images that he was viewing and the fact that he was an audience to those videos. What's your next argument?
Well, can I say a couple things about that, which is...
If it's moving on to your next argument, certainly.
Sure. My next argument is that there are other protective factors here that make him unlikely to reoffend. So the psychiatrist, Dr. Krieger, said that he was less likely to reoffend than 99% of other sex offenders. There are 3 mental health reports that say he is unlikely to reoffend. He responded very well to treatment and has been diligent in treatment. He has a support system, he has a job, he lives independently. And
I'm glad you said that, a job. He is a cybersecurity officer, and certainly he has certain tools that's going to give him more access than others with respect to accessing these images. Would you agree with that?
I wouldn't use the word officer. He works in cybersecurity. I don't think he has more access. I think there may be a disconnect here, Your Honors. These images are everywhere. They are very, very, very...
Let's talk about the images, because in 5 months, short time, he, obtained many. Went so far as putting them in categories. You want to talk about that?
You can click... He had 1,500 images were found. You can push one button and get a file that then you unzip, and it has 1,500
Let's
images.
go back to People v. Johnson.
Categorize it, and then he took time to categorize it.
And then disseminated them. It's not just that he kept them, he organized them and disseminated them. Why isn't that significant?
All of this can't be shown to increase his risk of reoffense. The point of SORA is not to further punish him. I understand you all are saying you want to punish him more.
That's
not what
we're saying,
We didn't say that.
I'm hearing that you're not...
No. We asked you questions.
You would like the, right?
Counsel, that has nothing
SORA
to
is
do...
not purpose of that.
May I just say one thing? We are here dealing with the issue of SORA, and whether or not the court should or should not have granted a downward departure. Whether I am displeased with the sentence that was imposed has absolutely nothing to do with my determination here, okay? So let's be clear about that.
Okay.
This bench is not stating our position as to any aspect of this case other than the SORA and whether or not a downward departure should have been granted.
The question is the gentleman at risk of reoffending? And I submit to you the record is ample to show that he is not, and this is a classic case where the RAI doesn't apply accurately to a person in these circumstances.
I want to go back to below because People v. Johnson, I think we can agree that children who are depicted in pornography constitute victims. You'll agree with that, as per the case.
That's what the law is, for sure.
Right, okay. Oh, I have 3 more questions for you. And then certainly because there was no relationship, they're strangers. You agree with that? Per the law.
Correct.
All right. Last question. Now, below, defense counsel indicated to the SORA court that he could not argue against the 80 points because of People v. Johnson. But nonetheless, he still felt constrained to say, no. I'm paraphrasing.
That was me.
That was you?
I don't agree.
You said that?
Yeah, I said that. I said I don't agree with the Johnson case. So I wasn't going to concede points that I didn't agree with. But I'm not appealing on that basis. I'm appealing because there should have been a downward departure because people who film children they know or obtain child pornography.
They knew them? He had a relationship with them?
Can I finish?
No. I'm asking you.
Yes.
He had a relationship with them?
No, he did not. And that makes him less dangerous than someone that did. And that's what the board is saying. And there's this disconnect where the board routinely scores 30 points in this, and the courts direct 80 points because the board does not accept this concept that child pornography offenders should be treated like hands-on offenders for whom the RAI was created.
So, counsel, what is it that you state are the mitigating factors which would prompt a downward departure?
Okay, besides the Johnson anomaly, the fact that he has 3 mental health reports that say that he presents a low risk of reoffense, the fact that he has had an exceptional response to therapy and sex offender-specific treatment, the fact that he has wide support from his family and friends, as indicated in the letters that were submitted, the fact that he has no prior criminal record, and the fact that, indicative of this is the fact that Judge Rakoff sentenced him to time served.
I thought it was okay, conditional discharge or time served. Thank you. You have time on rebuttal.
Good afternoon, Your Honors. Assistant District Attorney Saad Siddiqui on behalf of the respondent people of the state of New York. Your Honors, I will start by saying that the SORA court, Judge Bruce, providently exercised its discretion, sound discretion in denying defendant's request for a downward departure. The defendant did not present any mitigating factors that were not adequately considered by the RAI.
What about the psychiatric reports that counsel keeps talking about?
Well, Your Honor, there were 3 psychiatric reports. One was a psychosexual evaluation. One was a psychiatric evaluation done by the court-ordered psychologist. And then there was, of course, defendant's personal psychiatrist and treating physician, Dr. Muntz. The 2 reports that were done, the psychiatric, the court-ordered psychosexual evaluation and the court-ordered therapeutic analysis, that was done largely at the behest in 2021 and 2022, both, I think, for dispositional purposes. That went specifically to whether or not Judge Rakoff is going to impose a sentence of incarceration. The 2023 letter from Dr. Muntz, from his personal psychiatrist, in that, Dr. Muntz talks about how defendant has had an exceptional response or a positive response to sex offender treatment. Here's the problem with that. She never actually talks about how she had any communication with the sex offender treatment provider. She bases this off of her review of her interactions with defendant. She says he's a different person. That's in Judge Bruce, in the letter she sent to Judge Bruce before the SORA hearing. She never even mentions or acknowledges who the sex offender treatment provider actually was. In the psychosexual evaluation done, the defendant admits and acknowledges that he is under sex offender treatment, and he commenced it in April 2022. But again, Dr. Muntz never took the additional step to actually speak to the sex offender treatment provider. In appellant's brief, particularly in their reply brief, they mention how they had met their burden because Dr. Muntz was sufficient. Yes, hearsay is allowed at a SORA hearing, but it still has to be reliable. How is it reliable to go and say, well, I spoke to the patient, the defendant, he said he's doing wonderfully in sex offender treatment, but I didn't actually go and speak to the sex offender treatment provider. There is no sex offender treatment report, evaluation, update. Maybe he's doing well, but well is not exceptional. We have no basis to make that finding and that determination. More importantly, the controlling case on this issue is People v. Galati. And you look, and pursuant to the Court of Appeals decision in Galati, you look at the totality of the circumstances, the totality of the charges, the cases against him. The appellate points to the fact that as compared to other federal cases, where the average number of images and videos possessed is 4,500, and he attempts to minimize the defendant's conduct in that this was only 1,500. That may be true with relation in comparing it on a sliding scale to federal standards, but objectively, 1,500 images and videos is, I mean, it's just a huge amount. And these were not simple images of children being posed. These were graphic images and videos of children, prepubescent, as early as, in one instance, one video, which was very troubling, appearing to be less than 5 years old. And forced to perform very sexually explicit acts. I won't get into that.
Counsel?
Yes, Your Honor.
Can you just address your adversary's argument that the analysis that is being used is akin to someone who's had sexual contact with a child, wherein a stranger contact as opposed to someone you know, that analysis is being used in the pornography context?
I certainly wouldn't categorize it that way. To the extent that there is a Johnson anomaly, as counsel addresses, largely that was also contingent, and going back to the Court of Appeals decision, it speaks also to instances where you had objectively a small number of images and videos, 2 or 3. In fact, the very cases that counsel relies on in his appeal are 4 cases where, and I believe those cases specifically dealt with individuals that had 3 or 4 images. I think the most number of images had to do with 150. These are cases that counsel cited in his brief, referring to where the appellate courts overturned the SORA court's finding in those cases. In those cases, it was as little as 3 to 4 images or 150 images at most. Again, so it is either 3 to 4, which is 1% of what we're talking about here, less than 1% of the number of images as in this case, or 150, which is 1/10 of the imagery that we're talking about. To the extent that he's talking about this Johnson anomaly and how that's what's ultimately dispositive and should be controlling, it flies in the face of the analysis imposed by the Court of Appeals in Galati, which was, again, you look at the totality of the circumstances and the conduct. And to the extent that what would be the most telling would be his response to treatment, we don't have any information from his sex offender treatment provider. What we have is a letter from his psychiatrist, his personal treating psychiatrist, who'd been treating him for several years, during which he was actually looking at child pornography. He admitted in his interview to the Department for the Federal Probation Pre-Sentence Report, he started looking at this when he was 17 years old. He was arrested in 2021 at the age of 23. He had been looking at these imagery for 6 years. At one point during his hospitalization, he admitted it to the hospital treatment providers, and it's in the...
I'm sorry, how old was he at the time of this incident?
23 is when he was arrested in 2021. He's 26 now. When he admitted this to, while he was hospitalized, to the treatment providers, they understood, and they told him to get rid of the computer, which is exactly what he did. Based on the totality of all of the submissions and the lack of any reports, not from the actual sex offender treatment provider. The people's position, the respondent's position, is that he was appropriately assessed a level 2, and that the court exercised its sound discretion in denying his request for a downward departure.
Thank you.
Thank you.
I think I need to spend my 2 minutes defending Dr. Mons.
So do we have anything from the sex offender provider stating how the defendant is doing or how he was doing at the time?
So at the time of the hearing, the only update that we provided was Dr. Mons's letter. At the time of the sentencing, Dr. Krieger is partners with the provider, Dr. Meg Kaplan, and provided information on how he was doing for the year or so that the case was pending in federal court, which I think is the exceptional response, the first exceptional response we should look at. And then the second one would be from that period when he was convicted until the sex offender, the SORA hearing.
What does that mean, doing exceptionally well or doing well?
Well, it means embracing the treatment, participating with it, being open. The admissions that my colleague just talked about were open admissions that he made to Dr. Krieger and then to probation. There was no evidence. Law enforcement didn't have any evidence of him doing anything wrong when he was 17, but he was open and forthright with Dr. Krieger and with probation about what had happened when he was 17. Also, so Dr. Mons has been with Mr. Belitz since 2014, is the first thing she says, and she noticed the change in him. She had been with him through hospitalizations for mental health issues, and helped him through the medications and to change his medications, and through the death of his father, which was the period in which.
But I thought that during this period of time, he was also viewing these the videos and the images.
It was during a period of time when his father fell ill and died not much later that was happening.
So my point was, so he's under care, he's seeing a therapist or what have you, and at the same time he's viewing these images.
That's true. That's true. But that doesn't make him more dangerous.
I was just trying to get a timeline. Right. That's all.
But if I may, it doesn't undermine Dr. Mons's opinion. She saw him through the death of his father, through the things, his hospitalizations, through his use of these images, through the arrest, which worked. It worked. It made him come clean about what he was doing and stop. And that's why he should be level 1.
Thank you. Thank you both.